Hello and welcome to Module 20. Today we're talking about bank supervision. So this is really sort of, I guess, the crux of what compliance people are thinking of when they are making decisions and kind of ensuring that they are complying with all the laws, regulations, and potentially best practices. One of the things that we have talked about off and on that we're seeing is that there are more requirements that are based on the asset threshold. As we've talked about, we have seen in the United States a system of large banks and community banks, and they're very different animals. So, one of the key things as a compliance professional is to really determine, what are your compliance obligations, and that may depend on your assets. And so I have a little statistic up here you see that, a fifth of banks have less than 100 million in assets. So these are very small community traditional banks, and they are subject to a bit more of a streamlined process. On the other hand, we now have 4 banks with greater than $1 trillion in assets. And so needless to say, they need very, very different regulation. And most likely the small banks are state chartered, but they're still going to be FDIC insured, and the large banks are going to be national banks. So they will not have any real state regulation, or certainly not state supervision and examination. We did talk briefly at the end of the last module about the stress testing. This is a requirement that applies to the largest institutions, those with greater than 250 billion in assets, and it has now been extended to holding companies with greater than 100 billion in assets. And so this is a requirement that's really aimed at determining whether or not the absolute largest institutions can withstand different negative economic scenarios. And this is, as I said before, public, and the scenarios are public, and how the top institutions do is public. But this is only required of the largest institutions because there is this concept and this concern referred to as too large to fail. The idea that the largest institutions, such as those with over $1 trillion in assets, could never fail. The government could not allow that to happen. And so it's important that we know that they can withstand potential downturns in the economy. And so this is really the greatest example of the type of different supervision that we see based on asset size. Getting into sort of more of the basic supervision that we read about in our reading, and that we've also seen examples of, is all banks have quarterly financial reporting. Those are where you get those reports that I've shown during some of the modules, and that you can all access at any time at the FDIC webpage. And so there is ongoing quarterly self-reporting by all FDIC insured institutions. There is also on-site examinations, and I can tell you from experience working with banks, and any of you who may work at a bank, this can be a stressful time because the examiners do come and they have access to everything. That's something to keep in mind. Bank examiners can see everything. This includes attorney-client communications. There is no such thing as an attorney-client privilege between a bank and its examiners. Now, it says here on this slide that they are examined every 12 to 18 months, and that really depends on their score on CAMELS, which we're going to talk about. But if it's a very large institution, there is likely kind of an ongoing examination process. For a very large institution, the exam really never ends. It just moves through maybe different sectors of the bank. The OCC will be the entity that examines the national banks. The FDIC always has authority to examine all the institutions. But in reality, it typically only examines directly the state chartered institutions every other year, sort of alternating with their state regulator. But what happens is that they all share information, and they all have the ability, if they have a concern, or if a concern comes to their attention through a customer. If a state bank isn't a member of the Federal Reserve Board, which are the larger institutions, the FDIC typically allows the Federal Reserve Board to do the every other year federal exam. The Federal Reserve Board has examination authority over all banks that are members, and that's all national banks and the larger state banks and the bank holding companies. Again, like the FDIC, it typically defers to, say, the OCC for the national banks, and potentially the state examiner on an every other year basis for the state chartered banks, but it definitely does ongoing examinations of the bank holding companies. And then the final federal agency that we see with supervisory authority is the Consumer Financial Protection Bureau. And this is an interesting scenario because they have direct examination authority over banks with assets greater than $10 billion. And what that means is that they can go to those larger institutions, schedule an exam, request information on a schedule of their choosing. Whereas a smaller institution, they still have supervisory authority, which means if they are concerned about something, a complaint has been brought to them, they can go in response to an actual concern, but they cannot just go in and examine them. And so it's a pretty significant difference whether or not an agency has actual examination authority versus the ability to respond to concerns and complaints. So that was very definitely part of what was negotiated when the Consumer Financial Protection Bureau was enacted. The small institutions were like, we cannot have an entirely new agency examining us. That's too much. So for the smaller institutions, the FDIC or the OCC or the state examination is going to include all the consumer aspects. Whereas for the larger institutions, while the bank regulators will look at that as part of obviously compliance, they won't be focused on it in the same way that the CFPB is focused on essentially harm to consumers or the lack thereof. The other regulators, and this was actually sort of part of the creation of the Consumer Financial Protection Bureau, they're concerned with compliance because for a bank to be operating well, they need to be in compliance with the law. So it's more of a compliance with the law and avoiding, say, litigation and things that flow from non-compliance, as opposed to a consumer focus. And that was sort of the rationale for creating this new agency. So as I've mentioned off and on, there is a CAMELS rating system, and these are the areas, and it spells CAMELS, why it's called CAMELS. So it's essentially capital protection, asset management competence, earnings strength, liquidity, risk exposure, and market sensitivity. And so these are all concepts, hopefully, that sound at least somewhat familiar. And these are the areas that a bank during this examination is going to be rated on and given a score. And ultimately, it will receive a composite rating, although it will receive a component rating in each of those categories. But it is a more holistic approach, so it's not a mathematical process to get your composite rating, but this will impact your assessments as a bank, as well as if you're smaller, your examination. As we see in all of these 5-point systems, the bank needs to really be in 1 or 2, and ideally, of course, always in 1. We hope no one ever gets down to 5. So what is quite different about this whole process, and keep in mind that it's a very intrusive process. Like I said, examiners can look at anything, is that it is not public. Much of what we talk about is public, but this examination process, what the examiner writes to the bank, what score they're given, it is only given to the board of directors and senior management, and it is not to be shared publicly. So I suppose if a bank does well, that's too bad. But in general, it is designed to be a really kind of open conversation. And Obviously, if anything occurs in a report 2 years in a row or 2 exams in a row, that is a bad thing, but it is not to be used by the public. It's not to be used by the bank to promote itself. It's really to be used as, I suppose you could say, a learning tool. And a learning tool, you might say, for the bank to learn what the examiner wants. There are differences of opinion. Any of you who are actively working in compliance may know that those on the inside and those in the regulatory world have different views. And this is supposed to be kind of a public, a non-public, a private discussion. Obviously, the regulator has a lot of discretion, a lot of power. So oftentimes the banks will do what they're asked for, but they definitely push back. And that is also sort of a negotiation and a thought process that the executives, along with compliance, have to make a decision about. So I have a slide on each of these areas that are examined for. And like I said, we have talked on some of these, the capital adequacy. As you see, it's a very in-depth review, not just the level and the quality, but also, whether the bank has the ability to get new capital if needed. Are there any trends? Is it diversified? Are there off-balance sheet areas where they have risk? That's a big focus these days. Ties in with the earnings, which is another category. And really, what is their plan for the future? How are they going to maintain and grow the current capital? Another area is the asset quality. What kind of losses are they seeing? Can they control this? Can they predict it? And essentially goes to how are they monitoring and handling credit risk? Are they making good loans? Are they doing appropriate underwriting? And when there's been a problem, have they responded to it? Do they have that level of sophistication to really manage the assets that they have? As we saw right from the very beginning with the chartering process, they are really looking at the individuals. Do they have the knowledge? And are they not just knowledgeable, but are they actively involved? Are they aware of what's going on? Are they giving guidance? Are they being given the appropriate reports? Or are they just figureheads? And so they really are going to want to talk to the key management to see their knowledge, their sophistication, and really their involvement. Kind of taking us back to the Bel Air case, they do look at earnings because, if we want the bank to do well, they need to have good earnings. And, what are their prospects for the future? One of the things that is oftentimes criticized about the whole bank examination process and really the bank regulatory scheme is that it's very backwards looking. So there is a new emphasis on trying to have some forward looking process. And essentially that's what the stress test is all about, forward looking. If something happens in the the future, are you prepared for that? Do you have a plan? And do you have contingencies for unexpected events? And liquidity, that is always an issue. What is the appropriate level of liquidity? Traditionally, banks were not the least bit liquid. They make loans, pay back slowly, they take in deposits. That's not a super liquid business, except the deposit side where people can take them out. And so, how much do they keep in sort of liquid assets? It's a huge part of this forward-looking focus that we see after kind of the 2008 situation. And finally, we see them looking at sensitivity to market risk. Are they watching interest rates? Do they know what's going on internationally? What's happening with commodities? Do they know how to manage this? Are they diversified? This is always an issue because, like everyone, banks tend to specialize. And like everyone, if you specialize too much, it's not always great for the bottom line if the one area you specialize in goes down. So that's the normal process. But the other part is what if they find a problem, or what if, problem is brought to their attention? How can a regulator and a bank resolve these issues? Well, what we hope happens during an examination or even with a complaint is that everything is resolved informally. Ideally, nothing's even in writing. And a lot of items can be resolved that way. But the regulators are, in my experience, becoming more interested in keeping a written record, basically to see if things are being corrected. And so there will be an exam report, and there may be a written MOU, a memo of understanding. These are typically private, but not necessarily. And of course, if a company is a public company, this would probably have to be disclosed. But informal resolutions are both the most preferred and also the most common. The next, I would say, most common would be the consent order, very common in the banking industry because banks rarely take things to court. Although we've read a number of cases and will continue to do so, that is definitely the exception. Banking law is very much a statutory, regulatory, and sort of consent order type area, and it's becoming more so all the time. And a consent order is an agreement. It's a mutual agreement. It is more formal. There may or may not be civil penalties, but there are definitely penalties if it's violated. The beauty, I guess, for the bank of a consent order is there is no admission of a violation, but you do have to have a public stating of what the regulator thought was being done wrong, and typically an agreement to do things differently in the future. And if you're in compliance, you're really going to want to read every one of these consent orders. And they create an interesting kind of regulatory guidebook, I would say, because they definitely point out what the regulator doesn't like. Because when you have the allegations, those are the things the regulator doesn't like. And we have the practices, that's the things the regulator does like. Now, the question is, are those practices required? Are they best practices? Or are they being required, in this case, as a punishment for doing something wrong? There are a lot of complaints about sort of governing by consent order, but it does seem to be the way, the current way that the bank regulators operate. And obviously the banks too, because they choose to go that route. If things cannot be resolved, then the bank regulator can issue a cease and desist order. This is not going to be voluntary. This is a negative situation, being ordered to cease and desist from bad actions, and it will start the APA rights, which we're going to talk about in a moment. The same with a removal and prohibition order, which we're going to talk about more in the next module. There are also formal written agreements, which are not, they're not the same as a consent order, which is more of a settlement. And there is a whole system for civil penalties. And there are various tiers of penalties, and needless to say, they get into the millions of dollars very quickly, depending on sort of the level of fault that's viewed. And the final kind of draconian penalty is the termination of insurance. Now, having all these different penalties is really seen as a sort of a positive, because prior to, I think it was 1966, termination of insurance and revoking a charter was the only action that the regulators can take. And as we've seen over time, they have now a variety of tools, including the ability, as we've talked about, to bring actions not just against the institution, but against institution-affiliated parties, which are officers, directors, and attorneys and accountants. Again, that will be something we talk about a bit more in the next module. Some other items that we've touched on are the prompt corrective action, which relates to capital. These are different kinds of orders, or a safety and soundness order. These are just plans, basically they're plans, but if they're not followed, it is then considered an unsafe and an unsound practice, and further action can be taken. With any of these non-voluntary types of agreements, the banks do have access to the administrative process. And basically what that means is a notice of the charges or the action requested by the regulator, a requirement that basically the bank respond in a period of time, the right to request a hearing. You can either typically, maybe the regulator's hoping you'll agree, but if you don't agree, you can contest it and request a hearing. The hearing is there before an administrative law judge, and the two sides after this hearing, which is not a court hearing, a more informal process, then submit their own findings of fact and conclusions of law. The administrative law judge then reviews those and issues a report and recommendation to the agency. The agency then decides whether to adopt the report of the administrative law judge, or to reject it or to modify it. And ultimately, either party may then appeal to the court. But it is an arbitrary and capricious and abuse of discretion or not in accordance with law. So it's basically at that point, when you appeal to a court, it's an appellate process. There is no new evidence permitted. That all has to be submitted at the administrative law judge hearing. And so it's not a great process to find yourself in, which may be why we see so many matters settled by consent orders, and so few actions going through this process. So this kind of gives you a real overview of sort of the supervision of banks by their regulators. And in our next module, we'll really talk a little bit more about that, and particularly the concept of safety and soundness. So please feel free to reach out with questions. Thank you.